Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare and life sciences. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the lawyers at Epstein Becker Green, a leading law firm that has decades of experience serving clients in the healthcare and life sciences industries nationwide.
Today on Diagnosing Healthcare, we will discuss recent updates to the FDA and FTC guidelines as they apply to dietary supplement manufacturers, as well as new developments with respect to misbranding. Hello and welcome. I'm your host, Tracey Gonzalez. I'm an attorney in Epstein Becker Green's healthcare and life sciences practice based out of our New York office. Dietary supplement manufacturers face several simultaneous challenges in light of recent FDA and FTC actions. FDA's broad definition of misbranding has created some industry confusion, while FTC's updates to its health products compliance guidance have done the same. FTC has also updated its endorsement guidelines to target social media and influencer posts, as well as advertisements aimed at children. We'll discuss each of these developments and their implications for the dietary supplement industry on today's show. We'll also discuss the implications of the recent Marshall decision, which held that no scienter was necessary to find a defendant criminally liable for misbranding. If you like what you hear today, please subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts. Joining our discussion today is Jack Wenik. Jack protects health and wellness clients' livelihoods and reputations with scientifically driven defense strategies before the U.S. Department of Justice, the U.S. Food and Drug Administration, the Federal Trade Commission, state attorney general's offices, and other agencies. He also guides dietary supplement companies and healthcare providers in class action litigation and commercial litigation disputes. Hi, Jack. Thanks for joining us today.
Thank you and good morning.
Also joining us is Teddy McCormick. Teddy, an accomplished commercial litigator, represents clients in disputes with their competitors, business partners, suppliers, or customers. She helps grow their businesses while minimizing risk, whether regulatory, competitive, or from consumers. She has successfully handled almost every type of litigation that a supplement company could be faced with. Hi, Teddy. Glad you could be here today.
Good morning, Tracey. Thank you for having me.
And last but certainly not least, we welcome Zach Taylor. Zach represents a diverse group of healthcare entities, including physician practices, health systems, hospitals, dietary supplement companies, and clinical labs. He also helps clients navigate state and federal regulatory issues, including the anti-kickback statute and licensing requirements. Hi, Zach. Thank you for joining us.
Hi, Tracey. Thanks for having me.
So let's begin by discussing the FTC's recent updates to its health products compliance guidelines. These updates concern randomized controlled trials, or RCTs, and disclosure of negative information, among other things. Jack, can you walk us through these updates and how they affect dietary supplement manufacturers?
Happy to do so. The FTC published back in 1998 a guidance document for dietary supplement companies as to what was supposedly acceptable and not acceptable in advertising. One of the problems we lawyers face is that guidance documents have always occupied this sort of netherworld in the law, that they supposedly don't carry the force of law, but we all look to them as what the government thinks is the law, if you will. And you could see this when different administrations change. When the Trump administration was in power, several memoranda were issued, both by the Attorney General's office as the president, trying to limit the force of guidance documents in general. And when President Biden was inaugurated, literally the first thing that he did after assuming office was revoke all those memoranda and executive orders. So we're now back in an era where guidance documents issued by regulatory agencies, at least under the present administration, have renewed power and authority. And in the case of dietary supplements, the FTC attempted to update these advertising guidelines, and they now call them health products compliance guidance. And I think without droning on and using up all the podcast time, most lawyers who work in this space and defend dietary supplement companies would basically say that these, quote, revisions are just more of the same for the FTC. The FTC has taken a very aggressive litigation approach regarding health claims and advertising for dietary supplements. And the buzzwords we use are competent and reliable scientific evidence. You need competent and reliable scientific evidence to substantiate a claim. And the big controversy for many years, and has not been resolved by these revisions to the guidelines, is whether that definition of competent and reliable scientific evidence includes the requirement that a dietary supplement company conduct a randomized controlled clinical trial of its product. And Teddy and I have been litigating what the meaning of competent, reliable scientific evidence is for over a decade now. And it's supposed to be a case-by-case examination of the facts, if you will. But the reality is, certainly I think from the defense perspective, is that the FTC more and more is trying to push the dietary supplement advertising on a level akin with what you would do for a pharmaceutical product claim. For a dietary supplement company, what I think what the general public doesn't understand is that these are products that can't be patented. So anyone can go out there and make up some product and put it in a store that has, say, I don't know, calcium or protein powder, whatever it is. But you can't patent a natural ingredient like that. That means that the enormous expense of conducting a randomized clinical trial that you would do for a pharmaceutical, you could justify that because you can get a patent on that drug, the molecule ultimately, that would justify spending millions of dollars on that research. But you can't do that in a dietary supplement context. This is just economically not feasible. And so there is this constant tension between how much evidence that a dietary supplement company needs to have to justify or substantiate one of its product claims. And candidly, I think sometimes the problem is there's really a disconnect between the agency, the FTC, and the industry. And so these revisions to the guidelines remain problematic to the extent they still suggest that randomized controlled trials, clinical trials, are needed to substantiate product claims.
Jack, one thing that occurred to me is that the guidelines with respect to the RCTs, they don't clarify whether RCTs apply to key ingredients in the supplement or the dietary supplement as a whole. How do you advise clients when we don't know which one it is?
Well, that is another hot button issue for dietary supplement companies. And again, the enormous expense of conducting one of these trials is why so many dietary supplement companies, to the extent they can, like to rely on more generalized research of so-called key ingredients like caffeine or what have you. What I have advised clients is to try to piggyback on that research by kind of trying to meet the FTC halfway and run like what I call a pilot study. So rather than try to mimic what a clinical randomized drug trial would be with different arms and hundreds of subjects, maybe run a smaller trial of your product with maybe 25, 30, 40 test subjects. So something that's of a manageable cost. And you hope that that'll come out with results that are similar to existing research that's out there on whatever the key ingredient is you're including in your product, like I said, be it calcium or caffeine or what have you, and hope that that'll satisfy the FTC. I think the agency has become much more aggressive with the new chair, Alina Khan, who brings new meaning to the expression as a new sheriff in town. The agency has really changed dramatically in so many ways. It makes life much, much tougher for all businesses, not just dietary supplement companies, with their aggressive approach.
One other question for you, Jack. FTC's requirement that dietary supplement manufacturers disclose negative information appears to be particularly vague. The information has to be what they call serious. Have there been any instances where a company has determined that the negative information that they have was not serious enough to disclose it, and FTC actually pursued litigation or some other penalty?
I'm not aware of cases that have come about since these revised guidelines have been implemented. And being that they're only from December 2022, that's not surprising because it's been, only a few months since they've been in effect. But to your point, there is a lot of controversy with when this quote unquote negative information becomes serious to warrant disclosure. One example I can give from past cases is increases in blood pressure. There are a lot of products that one can take, over-the-counter medications, different dietary supplements, different foods you eat, riding your Peloton bike, that'll increase your blood pressure. But the question is, does it increase it to a clinically significant level rather than just increase it? And when does that require disclosure? And I think it's going to be many months or more years of litigation before we get any real guidance on when something rises to the level of quote unquote being serious.
Right. So in the meantime, clients, it sounds like are left to fend for themselves.
Well, as the saying goes, you got to make a living. So you got to continue to try to sell your product and advertise it as best you can. And Teddy and Zach will say just as much as I can. We review client advertising, and you never give a client really kind of a black and white answer. It's just different levels of risk as to what they want to say and how they want to say it and how far they want to push the envelope. And candidly, like I said, that advice changes depending on who is in power.
So sticking with FTC has also updated its endorsement guidelines to broaden the definition of the term endorsement, such that it encompasses things like tags in social media posts and so-called fake positive reviews. FTC has also noted that advertisements aimed at children are of, quote, special concern, end quote. Teddy, can you describe some of these new developments for us?
Sure, absolutely. So the FTC came out with its updated endorsement guides in June of 2023. They had not been updated since 2009. So as you can imagine, so much has changed in terms of technology over the last almost 14 years or so. So here, what the FTC is trying to do is expand the definition of endorsement to clarify that the rules apply to statements by virtual influencers, fake reviews, fake reviewers, which means real and non-existent entities. And as you mentioned, tags and likes in social media. These new rules are aimed at addressing the changing technological landscape, and in particular, the use of AI in marketing. Just to give an example that I noticed recently, I see a lot more advertising on Facebook than I did, say, 5 to 7 years ago. And what I'm seeing a lot of is you'll see a product advertised, like a sweater or a woman's sweater or something like that. And then underneath the advertisement, there'll be a number of comments. I love this. It's beautiful and it's so comfortable. What a great product. Things like that. I don't think I've ever seen a negative comment about one of these ads. And so it's sort of gotten me thinking, are these real consumers? Are they real reviews? I think this is really going to be a huge issue in the next 5 to 10 years as more marketers and advertisers embrace the use of generative AI. And as you also mentioned, one of the more significant changes that was implemented through the updated endorsement guides is the FTC articulated a stricter definition for clear and conspicuous disclosures. And this is where an advertiser has to make sure that anyone viewing the advertisement would understand that there is a material connection and that the person promoting the product is either getting paid or getting free product samples or something like that may or may not influence their opinion. The prior standard was that such disclosures only had to be noticeable and easily understandable. Now they have to be unavoidable, which means that a consumer can't miss the disclosure. They must not be required to click through or take other actions to see this material information. We were talking a little bit before about reviews. This has been a big push by the FTC. They've made it express that procuring, suppressing, organizing, upvoting, downvoting, or editing consumer reviews in ways that may distort what consumers really think of a product is a deceptive practice under the FTC Act. I know in the past, a lot of advertisers and companies have hired companies to help them sort of scrub and downgrade negative reviews or hide them. The FTC is really trying to push against that so that the consumer gets an accurate picture of what people are really saying about the product or the service. The FTC has also addressed fake negative reviews by competitors, and those are also now expressly considered a deceptive practice under the FTC Act. The endorsement guide, the updated endorsement guides also clarify that in addition to advertisers themselves, endorsers, influencers, brand ambassadors, and intermediaries such as advertising and public relations firms may be liable for deceptive endorsements.
I find this all very interesting. I'm one of those people that sees all of these ads on Instagram and what have you. And I think a threshold question is, do you think that the new endorsement guides assume too much naivete on the part of consumers? Do you think that maybe most people realize that influencers are in fact paid to endorse a product
So I think that's a great question. And from my perspective, it may depend on who the influencer is, who the person is promoting the product. I think most adults nowadays, if they see Kim Kardashian promoting a product, most of us are going to understand that she's getting paid or compensated in some way to promote that product, and then take that into consideration when we assess her promotion of the product. And same for, say, Gwyneth Paltrow or other very like A-list celebrities. But influencers run the gamut. And there are people who are influencers who may not be famous in what those of us who are north of 40 think means being famous. So there are influencers who may have, millions of followers or thousands of followers who a lot of us may never have heard of. One of the things I think about is these include what they call mom bloggers and people who promote less glamorous products like diapers or cleaning products on their blogs or their vlogs. And they weave that presentation in a way that it really may not be clear to the average viewer that this is an advertisement. And I know that's another thing. I think most of us have gotten savvy to it, but like if you watch a movie, I think one of the more famous examples is Apple products have typically, people open up their laptop, it's always an Apple product. I didn't realize initially that Apple was paying for those product placements. I think most of us know it now. But so I don't know if it's the case that people are too naive. And I think it probably is a good thing to require these material connections to be prominent.
You mentioned AI, and I found that a little frightening to think that I'm seeing an endorsement and it's computer generated and it's not even a real person. Is there any push underway to label or otherwise call out an AI generated endorsement?
That is something that I think is in the works. I think we're going to see more regulations, and the FTC is definitely paying attention to this. And how we're going to regulate AI is such a broad conversation. But I do think that you may in the future see something that either an outright ban on there being fake reviews, fake marketing promotions, or a requirement that it be disclosed. But right now, I think it's a little bit still the Wild West right now.
And one final question, Teddy. Where do you think FTC might be headed with respect to advertisements aimed at children? Do they have particular products in mind? Was there maybe a precipitating event that brought about what they're calling this special concern?
So I know that the FTC is really, really taking a hard look at how advertising is marketed to children. Just last month, they issued a staff paper that recommends that businesses and social media influencers and others who market or promote products online to children should avoid blurring advertising by clearly separating advertising and entertainment, educational, and other content to help limit potential harms to children. I know the FTC has been doing a lot of research in this field. And the research that they've been doing is that it shows that disclosures don't work for children the way they would for adults. So therefore, ads that including endorsements, which are directed at kids, may fall short of the FTC's requirements, even if they include a disclosure that adult would find clear and conspicuous, because a child just isn't going to, pick up on that the way that an adult would.
Right. That makes a lot of sense. So finally, where FTC has provided guidance, albeit vague and sometimes confusing guidance, FDA has not provided any guidance at all. Here I'm speaking about FDA's failure to provide guidance as to threshold levels of impurities for dietary supplements, which could leave a dietary supplement manufacturer facing claims of misbranding. And now the Ninth Circuit has ruled that no scientier is necessary for a criminal misbranding charge. Zach, can you talk a little about the Marshall decision and how you walk your clients through this disturbing new development?
Yeah, of course. I'll start off by noting that everyone in the dietary supplement industry should be aware of the Marshall case. And I know Jack and Teddy would agree that this really has potential to have far-reaching effects throughout the industry. Marshall involved a defendant, naturopathic physician, who was convicted of shipping misbranded drugs in interstate commerce in violation of 21 USC 331. So that's misbranding and adulteration, but in this case, it was misbranding. At trial, the court didn't require the government to prove that the defendant knew that the products he shipped were misbranded. The reason for that, or the omission of scienter requirement, or state of mind as it's known, was that the defendant had previously been convicted of misbranding several years earlier. So really what the case centered on was interpretation of 21 USC 333 or 333, which is what imposes criminal penalties for violations of Section 331. In that provision in Section 333, there are two sub-provisions regarding penalties. The first is a misdemeanor offense, which doesn't require a scienter requirement. The second has a two-part, and I'll read it because it's helpful. But the first part is if any person commits such a violation after a conviction of him under this section has become final, that's the first clause. The second being, or commits such a violation with the intent to defraud or mislead. Either one of those, that person shall be in prison for not more than 3 years or fined not more than $10,000 or both. So that's the felony aspect. And the Ninth Circuit really focused in on this first provision of Section 333 and looked at whether or not it actually required a scienter. And they held that it does not make any explicit to a scienter, only proof that a previous violation had occurred. The court went on to note that support from this position came from the statute itself, as the second clause explicitly provides a scienter saying the intent to defraud, and that previous Supreme Court precedent regarding what they call a public welfare offense, which involves statutes that regulate potentially harmful or injurious items, have been known to impose a form of strict criminal liability. So the result of that is because the defendant Marshall had been previously convicted, it functionally served as a substitute for any scienter requirement. There was no due process concerns in the Ninth Circuit's mind because the statute only permits conviction when it's shown that the defendant has committed a second violation after a previous conviction. In other words, the defendant had sufficient notice of facts to alert him to any potential future enforcement. The outcome here is not that any misbranding is strict liability. It's only if you've previously been convicted under Section 331. So the idea here now is that if a dietary supplement participant has had a previous misbranding charge, even a misdemeanor, any future charge brought by the government doesn't require any proof of scienter. And the effect of that is prosecution for misbranding has become a lot easier.
What bothers me so much is that you now have, I think it's the first time I am aware of, a felony level charge without a state of mind requirement that you didn't even intend to do it. So just think about that for a minute in a common sense fashion. A company pleads 10 years ago to some misdemeanor misbranding charge about product A, all right? And the government doesn't have to prove that they knew it was misbranded or anything was wrong with the label, strict liability. And 10 years later, like in the case that Zach is talking about, which was, I think, a 6-year difference, 7 years after conviction, a whole totally different product that, again, you may not have any awareness that it's misbranded or not. And now it's potential felony because you had a prior conviction. So it's in my mind, a very, very dangerous development for the dietary supplement world.
And I think what you've been alluding to, Tracey, about the vagueness, right, that this industry is under, it's just compounded now. So there's not guidance for the dietary supplement industry to look to avoid misbranding in general. It's an open-ended discussion that I'm sure all of us on this call could drone on for hours about. There's no real place for the industry to look to get clarity. And it has some serious implications now.
So I have two questions then to follow up on that. The first is, how are you advising clients in light of this decision now?
As a starting point, the general guidance we would give hasn't changed. Companies still need to ensure that their labels comply with the governing regulations. We always recommend, if you haven't done one recently, conducting an audit, doing a review of your labels, as Jack and Teddy mentioned, looking at your marketing materials. Starting with the baseline is always helpful. How do you avoid impurities is a problem. So as an example, just to kind of paint the picture for everyone and the implications from Marshall is there's a dietary supplement company that's sourcing their raw ingredients from an overseas supplier. And unbeknownst to them, the supplier's raw ingredient contains an incredibly low level of some impurity. It doesn't really matter for our purposes. And when I say low level, I mean parts per million, parts per billion. It's not practical for that company to test that product to find that impurity. Also, how do they know what to look for? There are thousands of impurities they could have to test for. And that gets us to the realm that Jack mentioned earlier of, are they supposed to be on the same level as a pharmaceutical company? But if the FDA happens to test the product for a certain ingredient or a certain impurity, a hot topic issue is steroids, and they find it in a parts per million, parts per billion context, then they can bring a misbranding charge. Now, at the start, that may end up in a misdemeanor or it could result in a felony, depending on what the government's able to prove. But if they're convicted of that misdemeanor under Marshall, any subsequent violation for a parts per million or parts per billion would result in a strict liability felony. That's the concern, is advising around that rat's nest, I guess is the best way to put it.
I think what you just said also begs the question, why do you think FDA has not adopted a threshold level for impurities for dietary supplements? It has such a standard for food, for drug products. Why are we lacking in this particular area?
I think that's the $1 million question. We know the FDA recognizes impurities being acceptable in certain contexts. I mean, in the pharmaceutical world, the FDA has allowed impurities to be present in drug products when a chemical breakdown occurs in the product, right? And it produces another chemical. You can look at the recent DC Circuit decision, Sandoz versus Becerra, to kind of get a glimpse of that idea. But reality, I'm not sure why they've chosen to take this tack other than to give them leeway to enforce as they seem appropriate. I know, Jack, Teddy, if you have some additional opinions there.
I think it's a power grab. I think the irony is, most people think that industry is against regulation, but there are a lot of circumstances where industry wants regulation. They want specificity. They want clarity. So to Zach's point, you think about all these other facets of life, like the EPA has specific levels of lead that can be in drinking water. There are regulations from the Department of Agriculture about how much rodent hairs can be in different food products. And so you have these very specific things. So industry has clear guidance as to what is and is not acceptable. And I think in the dietary supplement world, I think the FDA likes to vagueness because it gives them more leeway to bring enforcement actions.
Yeah, I was going to echo exactly what Jack said and just add that this isn't the first time we've seen this, sort of a failure to regulate by the FDA. They've also done that with respect to certain dietary ingredients, and it creates a whole host of problems where they don't go through the appropriate rulemaking process to ban an ingredient. They put out some initial, send some warning letters, take the position sort of informally that the ingredient is illegal, but they don't take the steps that they need to take in order to formally outlaw it. And then as a result, there's this sort of, again, limbo gray area. And once the FTC or the FDA sends out a warning letter, then you have class action lawyers sort of bootstrap on that. So it just creates a whole host of problems. And to Jack's point, sometimes the supplement industry is actually begging for regulation so that they know that they have clear guidelines in order to lawfully market their products.
So in closing, I think what we've learned from today's discussion is that dietary supplement manufacturers are facing a minefield of vague and sometimes confusing regulations, and in some cases, no regulations at all. And so a question for all three of you. Is there any reason to hope that either FTC or FDA will issue further guidance or clarification? And if so, which issues do you or your clients see as most urgent for the agencies to address?
So let me begin by noting that one hopeful sign I see, and we all three of us have been involved in this, is that there's been a pushback, not on the regulatory or legislative side, but in the courts to some of the excesses. You're seeing, not just in the dietary supplement world, but I think across the board, there's the Supreme Court's agenda, challenges to the SEC's authority, challenges to the new Consumer Protection Agency's authorities. You're seeing in the court system a lot of pushback against these regulatory excesses, which are around regardless of whether it's a Republican or Democratic administration in power. And I think that speaks to fundamental change in the sense that, at least in the judicial system, the appellate courts and the Supreme Court are saying, hey, regulators, you don't have unbridled discretion to do whatever it is you think you want to do. And I think you're going to see more of that as to the FDA, FTC, and a host of the other alphabet agencies, if you will.
Yeah, I would echo what Jack said and just add, we've sort of also seen this in the CBD context. There's been a lot of pushback by industry because the FDA have sort of failed to appropriately regulate when you can legally sell CBD products and THC products. And as a result, I think they are coming to the conclusion they're going to have to do it. I'm a little less optimistic in the supplement world, particularly, like I said, the issue with failing to take the steps to ban ingredients and just trying to do sort of an end run and just put it out on their website and do it via warning letters or individual litigations. But I do take some comfort for the reason that Jack said is there does seem to be pushback by the courts to some of these excesses. The challenge for us, for our clients, is litigation can be very expensive and you need clients, the stakes need to be high enough for clients to sort of take on that battle. So it has been happening more and hopefully it will continue to. So I think there's some positive trends and then some not so positive trends that I'm seeing.
Yeah, I would agree with all of that. And I would just add the common sense answer of the industry needs to continue to band together to lobby, to have these threshold guidance, to have guidance updated, to give them a clear pathway to move forward, because it's going to become an untenable position at some point. Because currently, right now, dietary supplement companies either have to test every product under the sun to check for every possible impurity, which is just not financially feasible and kind of defies common sense, or they just have to roll the dice and risk it. And to Teddy's point, litigation becomes expensive, even if you get a good decision out of the courts, which I think is necessary in some instances. I mean, especially now after Marshall, we're going to want an opinion in another sister circuit to say we disagree with that. And that's really the case here, is it's kind of attacking on all fronts, industry in and of itself, the litigation that we don't want to see, but we know is necessary.
Thanks, Zach. And I'd like to thank all three of you, Jack, Teddy, and Zach again, for taking the time to participate in today's discussion on the FDA and FTC guidelines and recent decisions impacting the dietary supplement industry. And thank you to all of our listeners. I'm your host, Tracey Gonzalez. If you like what you've heard today, please subscribe. Diagnosing Health Care is available wherever you get your podcasts.
Thank you for listening to Diagnosing Health Care. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare and life sciences, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.